Good day, everyone. Today we will be discussing an important and relevant topic in today's digital world, which is Lesson 3, Intellectual Property Rights and the Development and Use of Digital Materials, and it aims to help us understand how we can protect the rights of content creators, especially in educational and digital settings. Let's begin by looking at some data from past surveys that shows just how serious the issue of plagiarism has become in academic setting. Survey result from plagiarism.org 2002 to 2005 shows that 36% of undergraduates and 24% of graduate students admitted to copying from internet sources without citation. 38% of students and 25% of grads copied from written sources. 14% admitted to faking bibliographies and 7 turned in someone else's work. Another survey found that 1 in 3 high school students use the internet to plagiarize assignments. This number shows that plagiarism is a serious and growing problem in both schools and universities, especially in the digital age. So what exactly is intellectual property or IP? Intellectual property refers to creations of mind. This includes interventions, written and artistic works, design, and even brand names or logos used in business. Protecting intellectual property is essential because it encourages innovation and creativity. If we don't protect the work of creators, they might not benefit from their own creations, and this could discourage future innovation. Intellectual property rights or IPR are the legal rights that belongs to individuals or companies over the things they create. Or on an international level, these rights are protected by the World Intellectual Property Organization or WIPO. The Philippines is a member of this organization. Here in Philippines, we protect intellectual property through Republic Act 8293, which is implemented by the Intellectual Property Office of the Philippines. This law covers a wide range of property rights such as copyright, patents, trademarks, industrial designs, and even protection for undisclosed information or trade secrets. There are different types of intellectual property, but in education, the most relevant one is copyright and related rights. Other types include trademarks, patents, industrial designs, and trade secrets. Each of these protects different forms of intellectual creation, but copyright is the one we encounter most often in school, especially when dealing with books, articles, videos, music, and other learning materials. What is copyright? Copyright is a legal right granted to creators of original works. It protects their works from being copied, distributed, or used without permission. Some examples of works protected by copyright include books, articles, music, paintings, sculptures, maps, computer programs, and even films. One important thing to note is that copyright protection is automatic. This means it applies the moment a work is created, even if it is not registered. Whether it's a big or small creation, once it exists, it is protected. Copyright guidelines for online use. When using online content, always assume it's copyrighted unless it clearly says it's free to use. Here are some important guidelines. First, treat emails as protected works. Don't forward or share someone's email without asking for their permission. Second, you can download articles for classroom use, but they must follow the rules for photocopying or educational use. Third, do not post student work online, like essays or projects, without proper consent from the students and their parents or guardians. And lastly, always give credit when using online materials. Even better, ask permission before using someone else's content. Copyright infringement happens when someone uses a protected work without permission, violating the copyright holder's exclusive right. For example, if you upload a movie, copy a song, or use a photo without the owner's consent, that's copyright infringement. This is not just a school rule, it's a legal matter. People who commit copyright infringement can face lawsuits, fines, or even jail time depending on how serious the violation is. Copyright infringement versus plagiarism. It is important to understand the difference between the plagiarism and copyright infringement. Plagiarism is when you use someone else's work and claim it as your own. It is an ethical violation, meaning it's dishonest and misleading. For example, copying text from a website without citing it is plagiarism. Copyright infringement, on the other hand, is a legal violation. It happens when you use a copyrighted material without permission, even if you gave credit. In media, this could mean downloading music illegally or use copyrighted video clips in your own project. So remember, plagiarism is about honesty, while infringement is about legal right. To summarize, intellectual property law exists to protect creators and encourage innovation. In education, we most often encounter copyright laws, and we must always be careful to cite our sources and ask for permission when using others' work. Copyright infringement is a legal offense, while plagiarism is an ethical offense, but both can lead to serious consequences.